Good afternoon, everybody. Thank you for joining us. Welcome to the Becker Law Seminar on the new normal for community associations as we navigate the COVID-19 crisis. My name is Ken Director. I am the chair of the Community Association Practice Group with Becker and Polyakoff. And I want to sincerely thank all of you, the almost 2,000 of you that have signed up to join us today, and to the hundreds of you who have sent in questions. Be assured that we're not going to get to the several hundred questions we got, but I've read through them. There were some common threads, and I'll try to incorporate your questions into the questions I'm going to be asking our panelists. I want to emphasize that our panelists will be providing answers to general questions. These answers are not intended as specific legal advice to your community or to address your specific situation. For that, you will need to speak directly to your association counsel. Joining me today on the panel are my partners, Donna DiMaggio-Berger in our Fort Lauderdale office, Rosa de la Camera in our Coral Gables office, David Muller from our Naples office, and Jay Roberts from our Fort Walton Beach office. So we've sort of got the state surrounded. I want to start with some discussion of the most recent county orders, and Donna, I will direct the first question to you. Broward and Palm Beach have issued new orders in the last week to 10 days, and those orders have prompted a lot of new questions. What do these orders change with regard to the pool and pool decks, and how are the communities responding?
Well, let me first say, Ken, that there was tremendous public pressure being put on board members and public policymakers throughout Florida with regard to reopening pools and pool decks. And we've got a lot of different municipal and county orders out there that have slightly different takes on reopening pools and pool decks. Some orders, as we're going to hear later, don't even mention pools at all. But these orders have created a lot of confusion and a lot of questions out there. And I think to a certain extent, they have created expectations on the part of our community residents that might not be reasonable at this point in time. So let's talk about that a little bit. In Palm Beach and Broward, the response to the pressure being put to reopen pools, their response has been, in my opinion, to push that obligation back onto volunteer boards and their managers. And I think that's unfortunate. And I hope as these orders continue to be refined, that there's some understanding of the fact that this is not a one-size-fits-all order. These orders have a lot of gaps in there. They don't answer every question, and they certainly don't address every type of community. They don't address communities where there may already have been confirmed infections, where there may be underlying populations with health issues, older folks. So anybody listening, these orders are the floor of what you can do. They're certainly not the ceiling. Now, Palm Beach County Order number 5 said it used the language that the pools shall reopen, but provided that certain conditions could be met. And one of those conditions included having somebody, staff or management at the pool to monitor it to enforce the social distancing. The Palm Beach County order also required that shower facilities be closed and that there be social distancing enforced. But when you're looking at the monitor situation, we've had a couple questions already from folks living in Palm Beach County. One is who has to monitor? Does it have to be a paid staff member, or can volunteer owners do this, or can board members do this? Another question is, we're going to reopen 7 days a week, 8 hours a day, but we really only have somebody that can sit out there 2 days a week, 4 hours a day. In terms of Broward's order, that order is slightly different, and the semantics are slightly different, because the Broward County order says that pools shall remain closed unless certain conditions can be met. And those conditions include limited capacity, no guest usage of the pool, and cleaning of the facilities, the gates, the railings, the chairs, the tables, the equipment throughout the day. Now in Palm Beach, there is an alternative to that, Ken, which is remove all the furniture. And I would say that that's probably an alternative for any board in any location when they're thinking about whether or not to reopen the pool. They could also, even if their order doesn't talk about limiting guest usage like the Palm Beach one doesn't, or doesn't offer removing the furniture as an option, like the Palm Beach one doesn't, that may be an option that your board, wherever you are located geographically, says this makes sense. If we want to have owners bring their own furniture, if we want to limit guest usage, these are steps we want to take where we feel we can safely manage the reopening of our pool and pool deck.
And before I move off this question, just to clarify for everyone who's listening and to respond to the expectations of some of their owners, these orders do not mandate that the pools be reopened, correct?
That is correct. Even though I'm sure people listening are nodding their heads right now and saying the first thing we heard after these orders were released is, I assume our pool is going to be open tomorrow morning at 8 a.m. So that is a true statement. It doesn't mandate that they be opened. It says they may be reopened. Even the use of the word shall in the Palm Beach County order is qualified with a series of conditions you have to meet. Look, at the end of the day, the board has to be able to provide a certain duty of care when reopening the pool or pool deck, period.
David, I want to move to you because some of the clients around the state have asked, can we post a sign that says you use the pool at your own risk? And some communities are asking some people who come to the pool to sign a hold harmless agreement. What are your thoughts on that?
Right, it's important to remember those two steps. I mean, they from a legal standpoint, don't get the associations off the hook, right? If you just post a sign by the swimming pool that says swim at your own risk, and after it's posted, your board walks away and says, we don't have to worry about anything coming out of this. From a pure legal standpoint, no, it's not going to insulate you. Turning to the waivers, I know some communities are implementing a waiver system. Again, waivers are not bulletproof. You still have the same concerns. You still have the same risks. Candidly, from a waiver standpoint, a waiver is confirmation that the person is aware that there's a problem, right? Because they signed the form. But from a pure legal standpoint, waivers are far from bulletproof. And the reality is, if the board doesn't feel comfortable opening up a facility, opening up a swimming pool, then you should just simply keep it closed. You shouldn't think that by posting a swim at your own risk sign or implementing a waiver, that somehow is going to get you off the hook. If there's a concern, keep the amenity closed.
And David, I assume that in Southwest Florida, you're specifically in the Naples area, I assume it's safe to say that there were a lot of communities that did in fact close their pools and are still looking for ways to safely reopen them.
Right. So Southwest Florida has been a little bit different than Southeast Florida. Donna was talking about, some of the orders from Southeast Florida that directly have application to swimming pools in communities. In Southwest Florida, we haven't had that same issue. In Southwest Florida, the real focus has been on, at least from a governmental standpoint, reopening of the beaches and things like that. However, each community association in Southwest Florida, and we'll get into the details of this later with emergency powers and various other legal authorities, these communities do have the right to close their amenities. They have that right, and as the reopening process starts, they have the right to reopen. But one of the main things we want you all to take away from this webinar is you have to reopen in a smart way, right? You don't just callously reopen and keep your fingers crossed. It's a calculated decision.
I certainly agree. Rosa, how does the recent Miami-Dade executive order differ from what Donna described for Broward and Palm Beach?
Well, I think Miami-Dade County is kind of a different animal than most of the other states. First of all, it's the most populous county. And second of all, we have the dubious honor of having around 1/3 of the confirmed COVID-19 cases in our county. I think for that reason, our county mayor has been rather conservative. He was one of the first ones out of the gate to impose the emergency orders, and he's been one of the last ones back in the gate to lift them. Towards the end of April 30th to be exact, he signed another order extending the emergency orders for 30 days. However, there has been a bit of loosening up. What he did is he allowed certain recreational facilities to be open, such as parks, but the pools, he made our lives easy. The pools are not to be reopened, nor are the playgrounds. But in Miami, it's one of the reasons I say it's a different animal is because within Miami-Dade County, we have 34 municipalities. Every one of those municipalities has their own emergency orders and their own regulations, many of which are stricter than the county order. So remember, just because the county order says something does not mean your municipality is not going to be stricter. For example, City of Miami, the biggest municipality within Miami-Dade County, has been very strict, and they still have all of their parks closed. Miami Beach opened, you may have seen in the news, Miami Beach opened one of their parks and had to close it 3 days later, 5 days later, because the folks weren't keeping social distancing norms. Now, the county emergency order does open parks, but still remain in place the restrictions such as the social distancing, covering the faces with face masks, etc. So it's the reason I say it's kind of an anomaly is we have 4 layers. We have the state orders that Governor DeSantis issued. We have the county order issued by our county mayor. We have the municipal orders issued by our municipalities. And then we have the condo board orders issued by the individual condominium board of directors. One final comment that I will make, I have seen some associations reopening tennis courts because single play tennis is allowed in the county, doubles play is not. And interior or indoor facilities such as gyms and spas, by and large, are remaining closed.
Let's head north to you, Jay. In Fort Walton Beach and the surrounding area, what amenity closures have you experienced, and what are you seeing in terms of the reopening?
Yeah, so a lot like Dave's seen down in Southwest Florida, is really only pointed at the beaches. We had no municipal or county orders that really aimed at pools or other amenities for associations. But we did have them aimed at the beaches. And up here, we have something that's a little different than most of Florida in that the upland beach owner in most areas owns all the way down to the mean high water line. So for instance, in Walton County, the county issued an ordinance closing all public and private beaches. Well, what did that lead to? That led to something that I think is going to be important for our listeners and our watchers here today. It led to a federal lawsuit. About 30 upland beach owners, including former Governor Mike Huckabee, filed a federal lawsuit against Walton County and basically said, you are unconstitutionally seizing our property by saying I can't go in my backyard. They filed a motion for preliminary injunction in front of Judge Roger Vinson, who's our federal judge here. And within a week, the judge heard the case and heard the motion and ruled in favor of the county, shot down the motion for preliminary injunction. The reason why is basically laid out pretty simply in the order. The judge said, look, the county has to take protective measures. And this is a reasonable protective measure for a short period of time to protect the life, safety, and health of the citizens of Walton County, including those beach owners. So where does that leave us? Well, you as community association leaders should know that this is kind of a test case. What are the courts going to be saying when they're looking at protective measures, whether it be from the federal government, the state government, your local municipality, the county around you, or as Rosa pointed out, your community association? If they are acting reasonably and to protect the citizenry, I think Judge Vinson's opinion is going to hold some weight around the state when people are looking at these measures.
Well, it certainly reflects the kind of reasoning we would want to see if the steps that our boards have taken to implement safety protocols are challenged, is it not?
I think so. I think so. Look, it's always a risk. It's always a gamble when you're a leader and you have to make a decision. What I think our cohesive message will be today is making decisions that are in the best interest of protecting life, safety, and health in your community. It's where we're going to side on. I mean, that's what I think our leaders and government are trying to do. You can disagree, you can agree, but that's what they're trying to do. And you as a leader in a community association, that's where your headspace needs to be.
Well, it's also safe to remind everybody that the board members, especially the board members who are listening, you have a fiduciary duty to the association and to the members. The members who are demanding to use the pool and the gym, they don't owe a fiduciary duty to anybody. So you're going to be held to a higher standard in terms of the decisions that you make here, and you're going to be the ones held accountable. David, I want to shift focus to you because there's been a little bit of discussion with regard to the indoor amenities. Now that pools and pool decks are being reopened on conditional terms, we're getting lots of questions about other facilities. I read a lot of them from around the state and the people in attendance. What about the gym and the other indoor facilities?
Right, the gym and other indoor facilities presents a different type of consideration versus the swimming pool, right? Some things to keep in mind. Gyms are indoor, right? Your swimming pool mostly by and large are outdoor. It's smaller area than the swimming pool deck area often. You know, people who go to the gym, if they're doing it the right way, they're sweating, right? You know, you've got different types of considerations in the fitness center. From what we all know from watching the news nonstop of the past couple of weeks, those are all considerations for heightened risk of transmission. So the gym is a different animal as compared to the swim decks, the swim deck and the swimming pool areas. So I can see, and I have had clients that have opened up the swimming pool with certain restrictions, but they're keeping the fitness center closed. I have other clients that are opening up with certain restrictions. You know, they're the fitness centers with certain restrictions. They're having a sign-in sheet for when they can be used. They're putting limitations on the number of people that can use it at the same time. They're putting in requirements for cleaning, things like this. Those are smart, reasonable steps to take, but you have to remember, taking these steps, it has to be realistic, right? And if there's violations, you need to make sure that you're enforcing them. Because as we all know, we've known this even before COVID-19, a restriction that is not enforced is not a restriction at all.
And it bears repeating, and Donna alluded to this in her answer to the initial question, which was when we talk about the pool, when we talk about the pool deck, when we talk about the indoor facilities, including the gym, one size does not fit all. The communities around the state have different demographics, therefore different risk factors, different structures, different size of the room, different staffing to be able to clean the rooms. So you need to customize a plan that makes sense for your community when you look at the issue of reopening and adapting to a new normal. And as you do that, Donna, I want to circle back to you. As we've acknowledged, the demand to reopen amenities has been like an avalanche. And the boards are under the same sort of pressure that the county governments were under. And a lot of the questions that I'm seeing from the people in attendance are about risk and liability. The reopening of amenities, now that the requirement that they be closed being gone, does it create new risks for the associations that are doing so?
Well, look, there's going to be risks regardless if you take action or you don't take action. But one way to minimize that risk is for your board to engage in the same deliberative process that you hopefully used when you were evaluating which amenities to close and in what order. You know, most boards left the pool deck and pool open the last. As David alluded, it's outdoors, so there was the feeling, and this was even in some cases confirmed by medical experts, that was easier to enforce social distancing outside. So that was the last component to be closed, and we're seeing it in most cases as the first amenity to be reopened. So when you are evaluating, hopefully you are engaging in that same deliberative process of which amenities should we, now we're talking about indoor, reopen first. It's almost a rolling back of the restrictions you put in place. And let's talk about two examples. I think David covered the analysis that goes into whether or not to reopen the pool perfectly. But let's take it in a building. We'll use a condo. And in this condo, it's a 25-unit condo, but only 6 people are in residence, okay? You have a 20 by 25-foot fitness room. You may be able to safely reopen that right now through the use of some of the suggestions David made. It could be heightened sanitization. It could be a spacing out of the machines. It could be an advanced registration process. Take that same 20 by 25-foot fitness room and put 400 residents in your multifamily building, and you will find it's going to be much harder to safely reopen that fitness room at this point. And for everybody listening, I know you all have a neighboring building where your residents are going to come to you and say, but they can do it. I feel like I'm having conversations with my kids all over again about how come we can't do it. Our neighboring building can do it. for my HOA example, in terms of evaluating your risk, let's take a large clubhouse. When we're talking about communities with an abundance of amenities, what are we really talking about in Florida? We're talking about many of our retirement communities, correct? And those are the communities with the most vulnerable population. So again, if you're on a board of a retirement community or even a non-retirement community, but you're in a building, you're in a community with a lot of at-risk people, your evaluation has to be slightly different. If you've got a clubhouse with many, many rooms, you may want to start with reopening the largest room where it's more easy to enforce social distancing. And those little rooms, we're all familiar with them. All of my colleagues here, we've all been in one of those rooms at one point or another for a meeting. Those are the rooms that are usually used by the social committees or the card club where more intimate gatherings take place. You might want to wait until the risk passes to open those kind of rooms at this point. And again, the overarching concern is if we can't provide a certain level of care at this point, then it's simply premature.
Rosa, we're still under a national, statewide, and in pretty much every county in Florida, a local declared state of emergency. We're still under stay-at-home orders in Miami-Dade, Broward, and Palm Beach, and I suspect through the rest of the state. Some of the residents are seeing the opening of the pool as an invitation to relax the restrictions on non-essential visitors, whether it be guests or contractors or family members. What are your thoughts at this juncture on permitting housekeepers, realtors, contractors, non-emergency visitors or non-essential visitors to the property?
Well, you really can't compare the two, Ken. One thing is opening the pool and enforcing social distancing requirements of your residents. And the other thing is opening the doors of the condo to allow non-resident third parties in. That might be a guest, that might be a housekeeper, and that could even be a contractor. Again, as Donna mentioned in her example, it has to be done on a case-by-case basis because there are some buildings that are more susceptible. There are some buildings that have a demographic that has a higher risk factor. You were all familiar with the case in Sunny Isles, which is one of the Miami-Dade County municipalities where the lady wanted her caretaker in and the board wouldn't let her in. Rightfully so, I understand, but they sued and the caretaker was allowed in because the unit owner in residence needed that person for her life, for her vital, taking a shower, feeding her, etc. So I don't think that we should let our guard down. And I'll give a short example. I recently had a condominium client a week ago, in fact, that had a contractor want to access the rooftop antennas because they needed to fix the antennas to get a better cell phone tower signal. That is not something that should be done now. This is not the time to allow third-party contractors in. We still have the social distancing requirements, and they, in my opinion, need to only allow those persons in the building that have the right to be there, not extraneous third parties.
And I think one point you made bears repeating. I don't think any of us on this call have ever suggested to clients since this crisis began that you should not treat necessary caregivers as essential visitors. That doesn't mean that they shouldn't wear a mask through the common elements. That doesn't mean they shouldn't wear gloves. And that doesn't mean that you should open the doors to every conceivable visitor who is not a necessary visitor, but that's a subjective evaluation and a case-by-case evaluation.
And
Jay,
that's just one thing. We can't say one size fits all because a caretaker is not going to be the same outside third party as the guy who wants to access the rooftop antenna. We have to use reasonableness as well in the analysis.
Well, and Ken, let me just interject that a caretaker comes in many forms. A lot of people think of a caretaker as a home health care aide, as in Rosa's case, somebody to come and help the woman with her vital functions. But I had a situation where the caretaker was really a babysitter that allowed an emergency room nurse to go back to work. So that's a conversation with counsel as to who constitutes a caretaker.
The permutations that you're going to face, and when I say you, I mean the board members who are listening and the managers who are listening, the permutations that you are going to face are frankly limitless and they warrant a careful discussion and an evaluation. And we're going to talk later in this seminar about the business judgment rule and how it empowers the board to take actions. And just as you would hire a consultant to do a concrete project or a roof project, the place to look for guidance on what you should and should not be doing in your community while we are under this pandemic is to look to medical experts. There is abundant material available from the CDC. There is abundant material available from the Department of Health. And you all have the ability to access doctors, whether they reside in your community, or doctors that you can contact for guidance on what is safe and what is not safe for your residents. I want to shift the gears a little bit, though, because this is another question we get frequently, and some of the people attending have asked this question. And Jay, this one goes to you. If cleaning staff is required for those who bring in visitors, contractors, even necessary people onto the property, can the association allocate the cost of that cleaning or that additional staff to those people?
Yeah, I mean, generally, it's the association's responsibility to maintain the common elements, and of course, that would include the cleaning. So in most circumstances, I tell clients, look, you may have some special ability. Let's say in your declaration, it provides for a tenant approval and a move-in process, and you could amend those rules and regulations to require deposits related to this. That might be a situation where that's appropriate. But I really want the community association leaders to be more holistic in their thought process about this. I know it usually is about the money, and trust me, everybody that's been to my class knows the first and last thing I say to every board member is protect the property, protect the money, but I say it in that order. And I want you to know that you need, when you're talking about these kind of things, protecting the property is going to be more than just can we charge for these services. It is, okay, what reasonable regulations do we need to set up in place if we're going to allow third-party contractors in? That's the holistic nature that I think the board is approaching this.
Jay, I want to stay with you because I want to shift gears. The restriction that was issued with regard to short-term vacation rentals was, to my knowledge, the only government order issued that actually specifically restricted access to the properties. The rest of the communities that have shut down access have done so without necessarily relying on an executive order or an emergency order, whether from municipal, county, or state. Does the board have the authority to restrict access beyond the specific parameters of the government's orders?
Yeah, and that's a huge one up here. As we all know, vacation rentals are a big deal up here. But my answer is very simple. I think the answer is yes. In the circumstances we're in, and I believe we'll probably talk a little bit more about emergency powers later.
We will.
You have the authority to restrict non-residents from coming into the property. Here's what I'll say about that. If you're going to make distinctions, there needs to be a reasonable basis for those distinctions. For instance, it's easy to say, look, essential people are allowed in, non-essential are not. But then if you're going to be more nuanced after that, all I'm saying as the person that has to go to court later and defend you is that we need to have a reasonable and rational basis for any distinction you're going to make with any group of people beyond essential versus non-essential.
It is a challenge because so many communities have changed their entire protocol for the delivery of packages. Some are requiring them to be left outside. They certainly, at least not in most cases, they're not allowing the delivery people to go to the door. We have a tremendous push right now for housekeepers. Housekeepers, particularly those who do it for a living, have been in who knows how many houses, exposed to how many different people. And when they come into the building, they create a risk of bringing the virus into the building. Now, I know there are some people who think this is just a media-driven hoax. We're approaching 70,000 fatalities. We probably passed that today in the United States. For the boards that are confronting these challenges, as Jay has been discussing them, when you are writing on a blank slate, when you're in uncharted territory where the law doesn't give you any clear guidance like it does for so many community association issues, you have to weigh the risks. David, I want to come back to you with regard to emergency powers. This is a very fluid situation. Can you give us some explanation? What is the extent of the board's emergency powers in this crisis, and when do those powers actually end?
Right. So the emergency powers statute, in each of the community association statutes, there is a provision including referencing emergency powers. It is triggered. Those powers are triggered when there is a state of emergency declared, which we've had. The statewide declaration for state of emergency expires later this week. It was for 60 days. And so we do expect that will be extended, but it hasn't been extended at this juncture yet. So the question is, what are those emergency powers? Well, the emergency powers statute was written with a hurricane in mind. It was not written with a pandemic in mind. So one of the initial questions out of the gate was, does it apply or not? And we've gotten some clarity on that particular issue. But what it says as it pertains to the pandemic is it gives the boards authority to take certain action to protect the property and the residents. And including in those powers are things we've talked about: closing of the swimming pools, closing of the fitness centers, things like that. So those expanded emergency powers, they're in play now. We expect the emergency declaration, at least statewide, will be extended. However, if it's not extended, the statute, the emergency power statute, doesn't automatically state that when the state of emergency goes away, these powers go away, right? There is some language that talks about it extending beyond that period of time. So an example we could consider is, let's say the governor does not extend the state of emergency beyond the 8th of May. But then on May 10th, a particular condominium learns that 5 of their residents test positive for COVID-19, right? My position will be that particular condominium, even though the statewide emergency declaration has gone away, they still have the right to take action to protect their residents in light of this new information about the infection having a mini hotspot within their condominium. So there's a misconception that as soon as the government pulls back away from some of these emergency orders, that automatically means the condominium or the homeowners association has to fall in line. It should be part of the factor, part of the consideration, but it's certainly not automatic.
The orders that we're seeing, as has been noted, certainly put the boards on the front line in terms of making these decisions, but they do nothing to remove the obligation of the board to do what all 4 of you have addressed, which is to protect the safety of the residents. So Donna, when this thing is over and we start to return to a sense of normalcy and we start to go back and even look at our governing documents, I imagine we're all going to have some different thoughts on amendments to governing documents that we've learned through the lessons learned from this crisis. What will some of those new ideas look like?
Now, that's a great question. Listen, in community associations, we consistently learn as each new crisis hits us, and we cope. And the way we cope is by incorporating new standards and often new amendments into our documents from the lessons we learned from the crisis, whether it was the Great Recession back in 2007 and 2008, or this new uncharted territory, the pandemic. I'm going to be speaking, and I assume David and Rosa and you and Jay, we're all going to be speaking, and all of our colleagues throughout all of our offices in Florida with our clients in the coming months about how to update their documents to take into account the lessons we're learning and we've learned. We've all looked at the questions that are coming in from the people listening in on this webinar, and many of those questions, we can craft amendments to address them moving forward. To David's point, David just went through a whole analysis of emergency powers. But one of the first amendments I would recommend is incorporating emergency powers into your declaration. Some of the limitations that David mentioned in terms of we have to be in a wait and see position until the governor issues the state of emergency. He did that back on March 9th. It's going to be in effect until May 8th. I think we all believe that state of emergency will be extended. But if you have this in your documents, you don't have to take a wait and see approach. We had the secretary of the DBPR, Halsey Bashirs, say that emergency powers were activated as a result of the governor's declaration of a state of emergency. But Secretary Bashirs did not say all of the emergency powers were activated. So why wouldn't we incorporate on a going forward basis emergency powers into our association documents that clarifies that it would be useful in not only a pandemic, but any sort of a medical crisis. That would speak to David's point of when does it end? Well, rather than tagging it to end when the governor's state of emergency ends, we can tag it until when the board reasonably believes the risk has been mitigated. I made a bunch of a list here. If you can let me, you know me, I've got a lot of ideas for amending the documents. Your leasing and sales provisions. We've all gotten questions about, we've got people still want to sell and lease their units, even in the midst of a pandemic. You want to look at the leasing and sales provisions to make sure you're not boxed in to a certain time period. If you need to wait and see what the risk is going to be, you may have a delayed move-in date. We can incorporate that into your leasing and sales provision. If your community, like many of Jay's communities, allows short-term rental activity, you may want to amend the leasing section to provide that short-term leasing activity may be suspended in the midst of a pandemic or other medical crisis. I don't know if you remember, but a few years back, there was an outbreak of Legionnaire's disease in a community because of the hot tub. So for our resort communities or communities, I know Rosa has a lot with short-term rental activity, you may want to update the short-term rental provisions that permit that activity in your documents to also allow the board to kind of hit pause on that activity when it's medically necessary to do so. Your guest occupancy restrictions, you may want to update those in the coming months to provide and outline what's an essential guest or occupant and what is a non-essential guest and occupant. Your useful use provision, we could update that provision to make it very clear that people who violate COVID-19 protocols or who violate a quarantine are now in violation of that lawful use provision in your documents. That's going to be terribly important. Jay mentioned enforcement, and I know we're going to be talking about that. Having that added language in your lawful use provision will be incredibly helpful to go to a judge and prove that this is the provision that these people are in fact violating. To Jay's point about cleaning costs, I absolutely agree. Let's add cleaning costs into our amendments on a going forward basis, that if we need to tack things on, including for move-ins, that the people moving in need to pay for heightened sanitization, we should do so. And then lastly, outside the scope of amending your documents, there's going to be other provisions you can update. For instance, I would urge boards on a going forward basis to make sure that the force majeure clauses in your construction contracts are mutual. That will allow you to safely hit pause on those contracts without incurring monetary penalties. Most of the construction contracts have force majeure clauses, but they're unilateral, which means the contractors can hit pause, but you can't. And frankly, many of the contractors wanted to push forward with the construction. Rosa talked about it, and I agree wholeheartedly with her. We don't need to probably be laying pavers right now in the midst of a pandemic, but from a contractor's point of view, they'd like to get paid. They'd like to keep working. So I think it's crucial to make sure that your force majeure clauses on a going forward basis would have a mutual clause. And then lastly, many of our communities require a uniform lease or a uniform lease addendum. Those could be updated to include language for delayed move-ins if necessary. And the rental and purchase applications could also be updated to include language about the potential, the possibility for a delayed move-in.
Donna, one of the hot button issues has been denying access to contractors to the units for renovations and other non-emergency repairs. Can that not be addressed as well?
That can be addressed, and we're talking about risk, and it's easier post-pandemic. We're going to be able to do certain things that can minimize the risk of economic damages. So a lot of the people who are complaining are saying, I may have lost a sale, or I may have lost a lease because of your COVID-19 protocols, or I may have incurred additional costs because of my contractor for my interior unit renovation because of your COVID-19 protocols. So those are some of the lessons we're going to learn, and we can address those in our amendments and our documents going forward.
Ken, you know why I love Donna's idea about these amendments as well, which is an added bonus, is that if the condos amend their documents as Donna is suggesting, it kind of mitigates and reduces the board's exposure to liability and risk, because the board is then divested of having to make those judgment calls. Do we have the authority to do this? Can we do this? It's clear, it's in black and white, and it's in their documents. And in a way, it really protects the board. So I love Donna's idea. Donna, A+.
And Rosa, I wanted to come back to you anyway. You have some short-term rental activity in Miami-Dade. Are you seeing any questions about perhaps waiving assessments or a spike in delinquencies because of the curtailment of rentals across the board and short-term rentals?
You know, we haven't really seen a lot of that yet in terms of owners failing to pay their assessments. Unfortunately, as draconian as it may sound, I think associations really have to move ahead and ensure that they continue with their collection efforts. They can't really drop the ball on that, because without the assessments that owners pay, there's no way for the condo to be properly operated and managed and maintained. But you know what a lot of my clients have been doing, or at least trying to do, is to get a line of credit from a bank and kind of park the money there for a rainy day. Because in case, God forbid, Dr. Fauci is correct, and in case in the fall or winter we have a second bout of this horrific disease, we aren't going to be lowering our defenses anytime soon. This is going to continue, this new normal, for longer than any of us would like to think. So if ultimately the assessment collection becomes affected and you have money in a line of credit for a rainy day or for even operating expenses that you can't otherwise meet, that should be done. And to Donna's point earlier, when the DBPR secretary issued their order, when Secretary Bashir issued the order and said some but not all emergency powers were in play, one of the emergency powers that isn't in play, according to the DBPR, is the authority of the board to seek loans unilaterally. And I have a condo that just went through this. They needed a bank loan, and their bylaws require a unit owner vote. They've not been able to get it yet. But imagine if we have that beautiful amendment in our governing document saying in a time of emergency, the board can proceed to do this. So I think that we have to get ready for that eventuality. Thankfully, I really haven't seen the decline in assessments yet. In terms of short-term rentals, real quick, I think that has definitely been affected, because most of my clients have implemented guidelines and protocols saying that no short-term rentals, or at least rentals in one way or another, are affected. Some of my clients have put rentals on hold until the emergency order is lifted. That's a tougher nut to crack, but I've seen it done. And, you know, I think in a way it depends on the extent of the board's rulemaking authority. So,
well, you know, speaking of having access to money, we are now less than 4 weeks away from the beginning of, wait for it, hurricane season. So for people who live on the ocean, it's been a good idea for a long time to have a standby line of credit. I want to come to you for a different idea.
Can I interject? I'm sorry, really, really quickly. One possible amendment that I left off, which I think we should all be looking at on a going forward basis, is the indemnification provisions in the documents. Those provisions that indemnify the board for the decisions they take. So much of the pressure that's been put on boards and some of the bad decisions we've seen being made is because board members may feel very vulnerable to take an unpopular position, even if they know it's in the best interest of the community. So I would also be looking at the indemnification provisions to specifically indemnify boards for the actions they take pursuant to an emergency plan.
And I'm sure the board members on the phone not only feel on the webinar, not only feel vulnerable, they probably feel besieged. But Rosa, I want to come back to you because Donna made some suggestions before about amendments to the documents. But we've also learned some lessons as we've navigated this crisis with regard to how to conduct meetings and how to operate our associations using technology. What recommendations are you going to have for your clients going forward in terms of operational changes?
Well, I think one of the things this has taught us, and I'm kicking and screaming the whole way, is to embrace technology. All the meetings that my clients have been doing lately are on Zoom, or even to a lesser desirable degree on conference calls. And there's no reason why that can't be done. Look at how many people we have dialed into today's, I think close to 3,000. There's no reason why a meeting for the association can't be held that way. One of the other things I think is very important is communication. There seems to be, I think, a dearth of communication whenever there's an emergency situation or a crisis, a hurricane, a pandemic notwithstanding. And I think it's important for the board to get the word out to the owners about what's going on, what they're doing, frequent email blasts. I like the idea of setting a specific time and date for regular board meetings, maybe once a week, maybe once every 2 weeks, maybe even once a month, that owners know this is the day that we're going to hold our monthly or weekly meeting, as the case may be. Also, I think it's really critically important in a case like this, back to the example where my board needed to get approval from the owners for the bank loan, it's critically important for times like this that you have electronic voting capabilities available for your owners, and even notification by email, consent forms collected from the owners. Those two things are really, really important because they allow you to function and to have your quorums and to have your board meetings and to have your membership meetings and, to be able to really successfully hold the meetings and let business happen as it normally would have happened, but for the fact that it's, instead of in person, it's being done, electronically.
To our board members attending, if Rosa is willing to embrace technology, there's no reason for you not to.
Don't make fun of me.
And anything, well, you introduced that,
I know.
but anything that facilitates communication and participation is worth doing.
Yeah.
The primary complaint we've heard from owners, I've been doing this for 36 years. The primary complaint you get from owners is that this was not communicated. The board didn't tell us what was going on. Things are being done behind closed doors. Things are being done in the dark. You remove a lot of the resentment by simply communicating better. So I certainly agree with that assessment, Rosa. Donna, I want to come back to you because it's time to talk about enforcement. We've all 5 of us gotten questions from clients about residents or owners who are violating their safety rules, violating quarantine, et cetera. Where are you with your clients in terms of what sort of enforcement mechanisms they're looking to enforce?
Well, listen, hopefully our boards have changed their focus over the last few weeks. And I can tell you, I think they have, because I'm getting fewer calls about emotional support animals for the first time in about 8 years. The focus right now is COVID-19 violations. And this is particularly true if you've got a confirmed infection or confirmed exposure in your community. I will tell you, my experience has been that once there has been a confirmed infection, a light bulb seems to go on and people get it as to why these protocols were put in place in the first place. But for those communities who have still not seen a confirmed infection or a confirmed exposure, they may be a little more, shall I say, blissfully ignorant about the risks and why these protocols were put in place in the first place. So the focus really now does need to be on violating those protocols and acting on them swiftly. They're not trivial matters. So there's things, and I know Jay is going to talk about this, and David, about the things we can do to enforce. I won't go into that. What I would say is focus on the things. It's almost like a triage situation right now. Focus on the things you should be focusing on, which is getting us through this pandemic. We want it in the rear view mirror. In the meantime, you may not want to focus on things that make you seem tone deaf. We've all seen the media reports, the nurse that had the medical vehicle, and they went after her for that. Knowing that you've got a lot of people working from home, people that either are at home because they're working or at home because they're taking care of somebody who's not ill. You've got children that cannot go to school. This may not be the time to start sending demand letters regarding the fact that in your homeowners association, the garage door is left open for more than a half hour, or somebody hasn't taken in their basketball hoop. Those are not the type of violations that I would recommend your board spend time and money pursuing right now. Take your limited resources and your time and go after the things that really have an impact on reducing the spread of this virus. So that would be my overall recommendation. Also, I will tell you, some people who push back against the prohibition on doing work inside the units, it's not only was that rule put in place in many instances to reduce the exposure to the virus, but think about this. Having a unit renovation going on next door creates what? Noise. And you probably have people on either side of you that are trying to either work, homeschool their kids, or maybe they're ill and sleeping. So I think the focus does need to change in the short term in terms of focusing on the COVID-19 violations. And I am seeing that from clients.
And I want to go to you, Jay. What are the enforcement options?
Well, you know, we have our standard enforcement options. We can talk about that. I'm telling you what I'm seeing, though, is I'm seeing a shorter fuse to get to me. What my client affectionately called Jay's love letter. So Miss Deborah in Unit 101 is violating the COVID regulations. And usually it would be a letter from the manager, maybe a letter from the board, and then it goes to Jay. But now I find that it's generally cut down to the time to get from violation, repeat violation, to we're getting the lawyer involved to deal with external remedies that the association have has become much shorter. So can the board and the association look at fighting and spending and those kind of things? Yeah, I think they can. I certainly agree with what Donna said as far as focusing your attention on regulations that are meant to protect life, health, and safety of residents. And what I'm seeing in my practice, what I recommend is that if those are the violations you're seeing, having a shorter fuse to deal with external remedies that a lawyer can get to is probably a good idea. And I'll tell you what I found. I've not had to run out and file lawsuits. My love letters are working, which is great. We love when people react in a positive manner and just say, let's make this all work together. But if you don't, here's what's going to happen. And that's what I'm doing.
Well, you commented earlier on Judge Vincent's ruling in the case against Walton County. Let's reverse the lawsuit and make it a case by people who are or case by the association trying to enforce against a violator. How's that case going to look?
Yeah, I think look, if I'm the trier of fact, I'm the person in the robe, and I have one side saying I really want to use the pool, and the other side saying I'm really trying to prevent virus outbreak. This is going to be an easy one for me to determine who's going to prevail on this. And as most people on the webinar know, in many of these cases, there's prevailing party attorney's fees that are going to be involved. So while the order may say, Miss Deborah, you can go to the pool, will also say you owe the association's attorney's fees for having to get us to this point. And hopefully just the letter at the beginning and explain that in a rational way that people understand.
Jay, David spoke earlier about the business judgment rule, and we're all familiar with the association hiring consultants to help them spec out and get bids on complicated projects. Explain how the business judgment rule applies in this context and how the board can defend their reasonable decisions as business judgment decisions in this context.
Right. So as everybody on this call that's looking at me knows, I'm a ray of sunshine that likes to bring good news to everybody at all times. And here's my good news for all our community association leaders out there. The law is here to protect you. There's something called the judgment rule. We have robust case law around Florida regarding it. And basically it says this: if you are acting on the advice of appropriate professionals and you are taking reasonable actions, then the courts are not going to Monday morning quarterback and come in and second guess your decisions as community association leaders. You know, we always talk about there's a high standard for breach of fiduciary claims, but this is kind of the other side of it. It is, look, we tried our hardest and we made the best decision we made. Well, did you rely on professionals? Yes, we relied on professionals. Well, did you act reasonably amongst the community and treat people similarly when you can? Yes, we did. Well, then we as a judge sitting 6 months in the future, a year in the future, are not going to go back and try to run into the quarterback about the decisions you made.
Well, and David, I want to kick to you a follow-up on the business judgment rule, because I made the comment earlier that we are in uncharted territory, and this involves a risk assessment. So assist the board members and managers that are attending this webinar with regard to what the risks are associated with being too restrictive, as opposed to the risks of not being associated with not being restrictive enough.
Right. From our perspective, from a risk management perspective, it is much better to err on the side of decisions that expose the association to economic damages, as opposed to decisions that expose the association to bodily injury claims. So what am I talking about? 2 examples, and you tell me which lawsuit, if you're an association board member, which lawsuit would you rather be part of? You adopted restrictions that said, you had a construction moratorium in place for normal times that said construction cannot begin until May 1st. Due to COVID-19, you decided to make that June 1st as opposed to May 1st. An owner is upset because they have a contract in place, a $100,000 renovation contract set to begin on May 1st, and now they are in breach of contract with their contractor because that same work can't be done until June 1st. And let's say it's a $5,000 penalty. Would you rather be exposed to a $5,000 claim for that particular restriction in that particular lawsuit versus a claim where the association took no COVID-19 restrictions, implemented no COVID-19 restrictions whatsoever, and 3 family members rarely left their condominium unit? All 3 were infected with COVID-19 and one of them died, right? And then they go and they retain one of these personal injury TV lawyers that sends you a real nasty letter demanding all sorts of things, right? So the question is, would you rather be involved in a lawsuit where $5,000 is in play, or a lawsuit where you've got bodily injury and, God forbid, a death situation? Clearly, you'd rather be in the situation where you're battling over $5,000.
And there are a lot of people out there thinking, well, how do you prove where you got the virus? Okay, fine. That doesn't prevent you from being sued, because in the United States, anybody can sue anybody for anything. So,
correct. And the other part of this equation is, if you are sued, will there be insurance coverage? And that's an important question. And I would encourage our board members to reach out to their insurance agent to have that discussion.
and based upon what we've seen so far, don't count on it. You're more likely to have insurance for the economic damage that you've caused than the bodily injury that you've caused. We only have a couple of minutes left, so I want to go around the panel for final thoughts. Donna, you first.
Okay. Well, first I want to thank all our board members and managers out there who have been coping with this for the last 2+ months. I don't think any of you would have signed on to work in a pandemic situation. And the fact that you haven't been tendering mass resignations is heartening. I will tell you, I served on my own homeowners association board for 2 years, and it was the longest 2 years of my life. And our biggest criticism at that point was over the mailbox design we chose. So thank you for continuing to hang in there. People elected you to be leaders. They're going to want you to lead. A couple final thoughts. One, to our board members out there, if you have a question that starts with the following words, is there liability if, okay, that question needs to be directed to your association attorney and really no one else, okay? There's a lot of information out there on the internet, but you need to be, if it's a question about your potential liability, you should be directing that to your association attorney. This isn't the time to go it alone for boards. We've talked a lot throughout the webinar about our safety nets and the business judgment rule. This is not the time to go dark. As Rosa said, it's more important than ever to be having regular, consistent information, because there is a lot of misinformation out there. And then lastly, I would say this, the counties, particularly the 2 counties I mentioned, may have created unreasonable expectations on the part of your members. It is your job, and we're certainly here to help you to balance those expectations. as you start reopening your common areas, your residents need to understand that they play a critical role as to whether or not those common areas are going to stay open. And by that, I mean, are they going to adhere to social distancing? If you've asked them to bring their own furniture, will they? The fact that they're hopefully not breaking in and breaking out your furniture. So again, you really need to make your members know that they play a key role. And most of the directors I know understand that being criticized is just a part of the job. It's an unfortunate part of the job of sitting on a board of directors. And they know all too well that they're going to be criticized both for reopening these amenities too quickly or reopening them too slowly.
Yep. Jay, final thoughts.
Yeah, what Donna said. No, I think that the important things to remember here. I agree with everything Donna said. By the way, I do. But I think the important thing to remember here is boards need to act with real information that they are working with now. You got to understand that what we know today is not what we're going to know in 2 weeks. We've got to be malleable in that situation. We've talked about that the law is going to protect you and that you need to act affirmatively. Donna talked about leadership. People, this is when you need a leader. And if you're on this call, you are been elected by your community to be a leader. Act like it. Rely on your professionals. Make sure you're taking affirmative actions to do what? Protect the property, protect the money, protect the people. That's where we are as a community, as a state, as a nation, as a world right now. Please keep that in mind locally.
Very good. Rosa, final thoughts.
Final thoughts, very briefly, once again, as painful as it sounds to me, embrace technology, use technology to make it more inclusive, to have your meetings, to include your owners. And one important thought, let's not forget, this is a dynamic, it is a changing world. What is here today will not be the same next week or next month. Remember that the protocol you adopt today is not the protocol of tomorrow. The boards need to meet. They need to update these regularly, and for those issues and for those guidelines that were already adopted, if you didn't do it according to the 48-hour notice and what have you, do it now. Ratify the decisions, because you have to have a legally sound basis upon which to enforce your guidelines. God bless you all and good luck. And no one mentioned my Dr. Burke scarf.
Rosa, if you think me or Jay or David was going to notice that, you're mistaken.
I would have, I just couldn't see it.
Okay.
David, final thoughts.
You know, it's a unique opportunity to do good. And if your communities are like the ones that I represent, have confidence in knowing that the silent majority has your back and supports what you're doing.
And I will conclude by first of all thanking David, Jay, and Rosa and Donna for a very, very enlightening discussion, a very practical analysis. I want to thank everyone for attending. And I want to remind all of you that for those of you who are clients of the firm, I know I speak for all 5 of us. We've been working every day for 2 months straight, responding to your emails, taking phone calls, being there for you. We are in this with you. We are here to help you. Use the resources that are available to you. And if there is a common theme to come out of this discussion, it is safety is the paramount concern as we navigate this crisis. Convenience is important, access to the amenities, mental health is important, but life safety is our paramount concern. Thank you everyone for attending. Thank you everyone for your questions. I know we haven't answered all of them, but we're trying. Thanks.
Thanks, everybody.
Bye.